Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. This edition, we're going to look at the clause in a will called no bond required. So, under the law in New Jersey, if someone does not have a will or the will was not done correctly, these cheap online things weren't filled out correctly, then the law says the person who becomes the administrator has to go and apply for what's called a bond. And basically, the bond is with some type of insurance company. And so it's called the surety bond. And the surety bond is an insurance policy that protects the beneficiaries and creditors of the estate. But most people already trust their kids. And so it's a added cost of could be 1,000 or more. So administrators, if there's no will required by law to obtain a surety bond in order to be appointed. Uh, Executors are not required to obtain this bond if the will waives that requirement. So a surety bond is always required, and one of the reasons for having this, sometimes the administrator or the executors don't have good credit, so they can't be bonded. So number one, have a proper will done by an attorney. Number two, if you already have a will, make sure that there's a clause that says no bond required. And then three, back to number one, don't rely upon cheap online forms, but have someone who knows what they're doing. Make sure that the will is properly done with a no bond clause and that it's a self-proving will. Remember, I'd say it's not a good idea to try to do your own electrical work, and it's also not a good idea to try to do legal documents that you don't have a good background. For more information, visit website njlaws.com. And for representation and will preparation, contact Ken Vercammen's office in Edison at 732-572-0500.